Let's talk about something super simple that is often misunderstood. No win, no fee. You've probably heard or seen it before, especially when it comes to legal claims. But what does it actually mean, and what should you check before you sign anything? This is a straightforward guide to how no win, no fee arrangements typically work in group litigation, purposefully built so you can make an informed decision. Group legal actions can be a really good way to hold big companies accountable, but solicitors' fees can be really expensive. Now, no win, no fee arrangements are designed to reduce the cost for upfront payments and make justice accessible, especially when a large number of people have all been affected by the same issue. Here's a simple way to put it: no upfront legal fees. If the case doesn't succeed, you typically won't pay your solicitor's fees, subject to the terms of your agreement, of course. And if the case does succeed, then a pre-agreed fee comes out of your compensation. But, and this really matters, no win, no fee reduces that risk, but it's not going to remove it entirely. A no win, no fee agreement essentially means that you only pay your solicitor if you actually win the case. If it succeeds, the law firm deducts a success fee, usually a percentage of your compensation. And that exact arrangement will simply be set up in the agreement that you sign. Now, even with no win, no fee, some costs may still apply, and these may include fee if you cancel after the calling off period, or breaching the agreement and the other side's legal costs in some situations. So that's why we know that reading the terms and conditions really do matter. The good news is that in most no win, no fee claims, you won't typically be paying these costs because there's usually after the event or ATE protection in place. ATE insurance is designed to protect you in case a case doesn't succeed, covering things like court fees or the other side's costs if ordered by the court. And often the premium is only payable if you win, but it's really important that you always check the agreement. There are two main types of agreements used in group litigation. Now, the first is conditional fee agreements, and this is the most typical out of the two. There are usually no upfront legal fees, and if the case succeeds, the firm may charge a success fee, which is essentially taken from your compensation at the end of the process. The next is damage-based agreements. Under a DBA, the firm's fee is actually capped at a percentage of compensation and subject to legal limit. Now, if your claim is successful, the law firm will go ahead and deduct the fee from your compensation. Now, before signing, you should always know a few of these things: the percentage being charged, whether VAT applies, whether insurance costs are included, and what happens if you cancel. So before joining any claim, ask yourself, what is the success fee percentage? Does it include VAT? Is ATE insurance in place? Can I cancel? And if so, on what terms? And which law firm is actually running the case? The Solicitors Regulations Authority has warned law firms about how no win, no fee claims are being marketed. So people must genuinely understand the risks and costs before signing. So at Join the Claim, we welcome that focus on transparency. If a group claim succeeds, compensation usually comes through something called a settlement or a court award. No win, no fee can open the door to justice, but only when it's understood properly. Take your time, read the terms, ask the questions. And if you want to see what group claims are currently being explored in the UK, you can visit Join the Claim to learn more.